Welcome back, everyone. Almost 30 years ago, Roe v. Wade guaranteed a woman's right to an abortion. Now, 3 women in New Jersey are challenging that decision.
Joining us today is Harold Cassidy, one of the lawyers handling that particular case. We've also invited the attorney from the state who will be defending a woman's right to an abortion, but he was unable to make it, so sitting in for him is our case-in-point attorney, Steve Wellinghorst. Welcome.
Good morning.
So you're filling in today, and Harold Cassidy, you're handling the case. Tell us how important this is. I mean, this is a groundbreaking decision, almost 30 years old, and now there's an attempt, at least by these 3 New Jersey women, to try to change or alter that. Is that a possibility after all these years?
It's an inevitability. It's an inevitability because nothing as bad as this is going to last forever. We've experimented with abortion now, claiming that it was in the interest of women to terminate the lives of their own children. The cases we're dealing with now exposes the impossibility of our culture to protect the most important liberty interest that any woman has in all of life, her interest in her relationship with her children, and protect the act of a doctor which is intended to terminate the life of that child. It's impossible.
Obviously, Steve, you have the other side, so we'll let you go at it.
As a pinch hitter today. It's interesting to me that the position taken by Mr. Cassidy's group seems to indicate that they have no real confidence in the intelligence of their own clients by saying that these women that went to get the abortions didn't know what they were getting into, didn't know what the process was going to be, and now, after having them, would like to sue their own doctors for performing them. It's interesting.
Indeed, Mr. Cassidy, you said that this decision, 30 years old, sort of made a decision for women, and women weren't happy with this. But still in all, it comes down to a woman's right to decide for herself, does it not?
I don't think you understand the facts of these cases. And the lack of understanding of the facts of the cases of my clients is part of the problem with the society's understanding of what's going on with this experimentation.
Well, give us a quick
explain
overview.
them. Yeah, explain them for us then.
We have 3 young women who had involuntary abortions or uninformed consent abortions. In one case, the woman was actually forced to have the abortion. We filed claims in the state court suing the doctors in wrongful death and survival action because they were negligent. The doctor had an absolute duty, as in any procedure in this state, to determine that the procedure was voluntary and to determine that it was informed. These doctors did not do that. We filed the suits on behalf of the women. These women didn't set out to overturn Roe v. Wade. They set out to redress a grievance against somebody who killed their children. When they came to me, what I had to explain to them was that the current state of the law in New Jersey is that the state pretends that the children didn't exist. They pretend that the mother sustained no damages. And so the doctors in those cases actually filed motions saying, we can't be sued, we're immune, even though we were negligent,
Right,
even though it was uninformed, even though it was involuntary. We can't be sued because you had no damages.
Let me just clear this up. There are procedures that a doctor has to take before a woman can get an abortion. You're claiming that that doctor or these doctors did not follow that procedure.
Absolutely. Not just an abortion, any procedure. In the state of New Jersey, as in most states, a doctor has the affirmative duty to tell the patient everything that a reasonable patient will want to know in making a decision of whether to forego or to have a particular procedure. These doctors did not do that, and in one instance, it was actually a forced abortion. So now we're in the federal court attacking the constitutionality of New Jersey's statutes.
All right. Now, Steve, that's a valid point.
It absolutely is a valid point, and I agree with that point 100%. What I have a problem with in this type of case is that you're comparing apples and oranges. When you have a medical procedure where a woman does not give informed consent to have the procedure done, that is a violation clearly under any New Jersey case law. That's clear. However, but now if you try to turn it into and roll it over into an argument saying that abortion shouldn't be performed because they're illegal and things like that, I think that's stretching the issue, and I think it's comparing apples and oranges, and I don't think that it can stretch that far under the current law.
How do we get to the point where everybody is talking about the fact that these women are out to overturn Roe v. Wade then? How did we get to this point?
Well, we get to that point, first of all, I want to point out that the governor has come in to the court and has sided with the abortion doctors, saying even though the whole theory of this is that it's a woman's choice. It doesn't matter that she didn't choose. It doesn't matter that it was uninformed. It doesn't matter that it was involuntary. We think our laws are okay. We think that our laws can pretend that the mother sustained no loss, even though we know it's the most important loss that any woman can sustain. That's number one. Number two, what we're saying, and we've already put in 8 expert affidavits, and we have another 8 to come, that based upon the experience of women in this country over the last 25 years, and it's the women speaking, that really there is no chance of having an informed voluntary waiver of this fundamental right until the baby is born. And that till now, what the women in this country have been told is that they're exercising a right. They're not exercising a right. They're waiving the most important right they have. And you can't waive a fundamental constitutional right unless it's clearly informed, unless it's clearly voluntary. One of the things we're asking the court now to do, as it relates to the mother's rights, not the child's rights, although the child is important, and I don't want to minimize that, but what's different about this, and what's important about this, is that we're asking the court to hold a trial now on the facts of the humanity of the child, that during the gestational period, this is a complete, separate, unique human being, as it relates to the mother's interests.
All right, now, Steve, if you're on the other side and you hear this argument in a courtroom, how do you defend that?
Well, you'd follow the case law and the argument that's been going on since Roe v. Wade. You just say that this is a woman's right to choose of what happens to her body and what someone does to her body. The court has determined in Roe v. Wade, and I had an opportunity to spend some time with Justice Blackmun right shortly before he died a few years ago, and part of what he had said was that this is a scientific decision based on science, to where he determined when life begins and where it doesn't begin. That argument is never going to go away, of when life is conceived, when it begins, if you have a difference between a child being born and then inside the mother, it's only skin that's separating the two.